In this video, we are going to discuss about the hearings at patent office. So let's assume few things and then we can proceed. You have filed an Indian patent application. Uh, it has been published, it has been examined, and you received first examination report. You responded to it with a written response, and now you got the hearing for your application. Now, what we mean by hearing and what happens in the hearing and what outcomes you can expect in general. We are not, explicitly mentioning anything, but in general, what you can expect to happen in the hearing is something that we are going to discuss in this video. Now, it's really subjective. I mean, a lot of hearings happen. Sometimes it's 10-15 minutes, sometimes 30 minutes, sometimes it can go for hours. And please understand that what we are talking is a generalized common knowledge about it, not any specific case. So be liberal about your understanding of what we are explaining here. Now, when we reach to the hearing stage, generally the objections are re-established. That's why the hearing is given. And it may be, the objections from the first examination report stage carried forward, or it could be additional prior arts that are found, or it could be any other reason for which the hearing would be there. So it would be list of objections, might be similar to the first examination report, or might be different from the first examination report. So we'll take the scenario one by one. Now, what we can expect in the hearing? First thing first, hearing is the discussion online, just like a Zoom meeting or Google Meet that you must have experienced with the government patent officials. Mostly it is controller or associate controllers or the team accordingly, depends on the hearing and complexity of it. And this discussion is generally starts with the, of course, mentioning the patent application number, the patent agents and their introduction and the client's scenario. In case if required, we can also start with the background of the client, who it is, why he has invented. That might establish some context, explaining the invention, what exactly it is, what objections that you have raised as a patent office, and what is our defense or our stand on those objections. If there are formal or corrective measures to be taken, then the formal objection can be overcome by promising that yes, we will do whatever is required. We'll file the required forms, we'll do the required corrections, and then that discussion can be handled for the formal objections very easily. It's generally the technical objections that requires major discussions, particularly with regards to the novelty or rather inventive step, non-obviousness. So these are longer discussions in general, and differentiating with prior arts and establishing why our invention is novel and inventive. And sometimes it's about section 3K objections for softwares, other sections also with regards to other inventions, these objections to be overcome with the discussion. So what we can expect as outcome for these, whatever presentations that we have given, whatever arguments that has happened, or whatever discussion that has happened, the question and answer that has happened during the hearing, there are 3-4 expected outcomes. The first thing first is the patent would be granted based on the arguments. That means the patent office has understood our arguments, or let's say our answers, and they have approved it, and the patent would be granted. That's a best case scenario. This is generally what happens when the objections are very minor, or it's just a formality wherein we discuss, we clarify, we show the tabular format and differentiation, and the patent office or the government officials agrees to it, and the patent would be granted. The second would be conditional acceptance. Now imagine a scenario where you are arguing for something, the patent office is arguing for something, and then the common agreement would be that the official says that okay, you need to make these changes, or you need to reduce the scope of the invention, or you need to delete this element, or whatever the correction would be, or whatever the conditions would be. And if you do that, then we might think of accepting the application. So this is kind of a oral communication here, but then the patent office suggests that you should do these changes, and then we might consider accepting it. So this is conditional acceptance. And the third outcome naturally is the rejection of patent applications. So imagine scenarios where you have not filed the patent application appropriately, not following the patent rules, the claims are not written as per law, or there could be a number of reasons. The hands down, the 100% overlapping prior arts are found. There is no novelty in the invention. There is no non-obviousness or inventive step in the invention. And even though we argue, we also know that there is not much matter in this. So patent office have that right to reject the patent application, and they can exercise that right. However, to be honest, I mean, they do give fair chance to us and try accept our arguments. And if at all there is some invention and some things that can be adjusted and patent would be granted, the patent officials are generous enough to consider it, and the patent should be granted if it is a capable invention having all the required, novelty, non-obviousness, and industrial applicability, and it is not objected by Section 3 by any means. So, long story short, more or less, it is a tug of war between the patent attorneys and government officials. Not tug of war exactly, but it's more of a fight for the scope of invention. Patent office would want the scope to be limited to whatever you have invented, and patent attorneys naturally would want as much broader scope as possible, so that that would benefit the inventor, or let's say the applicant. So whatever happens is the result of what happens in the hearing mostly, and if the adjustments are made properly, the patent should be granted in most of the cases. So I hope this provides you some glimpse about what you can expect in the hearing. As I mentioned, as a disclaimer, this is not at all a specific, this is a generalized overall consciousness, or let's say generalized idea about what can happen in the hearing. And there are always exceptions and special cases where whatever we discuss might not be applicable. So I hope you received some value out of this video, and you got some idea about what you can expect from the hearing at patent office. And hope you like the video. Thank you for your time. Take care.